Good morning, Mr. President, honorary members of the panel. My name is Brandon Zhang, and I appear with my co-counsel, Mark Maxwell Peter. We appear on behalf of the respondent, the Federation International de Football Association. I will speak for 10 minutes and respectfully reserve 1 minute for sir rebuttal. Members of the panel, this case is about upholding the integrity of the sport of football. In principle, sanctions and compulsory cooperation for fact-finding is essential for maintaining the image and integrity of the sport of football. There is no place for corruption and the manipulation of match fixing. I will speak on two issues. First, the procedural issue relating to the appellant's statement of appeal. Then I will speak on the second substantial issue, on the appellant's refusal to hand over his mobile phone. I shall now begin with the first submission. We submit that the statement of appeal filed by the appellant is not admissible for two reasons. First, the time of the receipt of the decision shall begin on the 31st of March 2026, as the appellant had the opportunity to obtain knowledge at the time of the decision. And second, the appellant, even if the panel takes the day of receipt to be April the 2nd, it still falls outside of the 21-day statutory time limit. On the first point, author Rigosi Hasler, in a Rural Manual's book, Arbitration in Switzerland, at page 498, writes, "It suffices according to the standing jurisprudence of the case that the addressee had the opportunity to obtain knowledge of the decision, whether or not the addressee had actual knowledge of the content of the decision is contrary. In the present case, if I may direct the panel's attention to paragraph 23 of the record, the decision was fully upheld on the 31st March 2026 by the FIFA Appeal Committee. And at that particular time, the appellant had already had legal representative as reflected in paragraph 23. The appellant and his legal counsel would have had on 31st March the opportunity to obtain knowledge of the decision, and at that particular time, that date would trigger the 21-day time limit. And because the statement of appeal had been filed outside of the 20-day statutory time limit, we submit that the statement of appeal is therefore inadmissible. Now, the appellant argues that the statutory time limit is on that begins on April the 3rd. Even if the panel takes that date to be the triggering date for the time appeal, that date still fell outside of the 21-day limit. The appellant raises the exceptional circumstance of a cyber attack. However, it is our submission that the cyber attack does not constitute an exceptional circumstance for three reasons, according to Rule 57 of the CAT Code, in which it requires there to be an exceptional circumstance. First, there's no confirmation of the actual date or relevant time period which the cyber attack took place. And this is reflected in Exhibit 9. Second, there's no confirmation whether there were any actual disputed and disrupted outgoing emails. And third, even if there were outgoing emails that were disrupted, it hasn't been proven that necessarily that the delivery error messages were not sent. And accordingly, because the appellant has not proved that in fact the relevant time period has been established, we submit that this is not an exceptional circumstance and that the statement of appeal is therefore inadmissible. If the panel members do not have any further questions, I will move on to submission number 2. Turning now to the second submission. The appellant had refused to hand over his phone when requested by FIFA on 2 accounts. We submit that this is unlawful for 3 reasons. 1, the applicable standard of proof is met and is only of mere comfortable satisfaction. And 2, the privilege against self-incrimination cannot be invoked. And 3, the duty to cooperate is absolute and strict. On the first point, according to Article 12, subsection 2, in particular, persons subject to this code shall help to establish and clarify facts of the case where possible. And subsection 3, persons shall help to establish and clarify the facts of a case and shall provide any evidence requested. According to the Collins Dictionary, which this panel and this court has frequently cited, the word shall means, I quote, indicate that something must happen, usually because of a rule or law. In the present case, if I may direct the panel's attention to paragraph 20, the appellant, I quote, immediately refused to cooperate repeatedly when FIFA representatives requested that the appellant submit his phone for the purposes of the investigation. The panel in the 2017 CAS decision, Jerome Valk versus FIFA, at paragraph 175, held that the applicable standard of proof is of comfortable satisfaction, i.e., less than the standard of beyond a reasonable doubt, but more than the standard of balance of probabilities. And we submit that the facts pertaining to the case proves that the appellant has violated the law more than a balance of probabilities. The appellant raises the self-incrimination defense pursuant to Article 6 of the ECHRT. We submit that in the context of sport, the privilege against self-incrimination is not always capable of being invoked, especially because this is a disciplinary proceeding. And the court has previously, in Castro's prudence, balanced interest involved in tips of the favor of privilege against in self-incrimination if a parallel criminal proceeding is pending or anticipated. However, the cooperation subject to the disciplinary rules of a sports association is necessary for the integrity and the image of the sport, and in this case, the integrity of FIFA. In the Jerome Valk versus FIFA case at paragraph 266, I quote, the panel stated, the danger that results of such cooperation in fact finding may at a later point trigger a criminal proceeding is per se not a valid justification to invoke the privilege of self-determination. In our case, a fortiori, there may be an applicable greater force where there is already an active criminal investigation, such as in our present case, reflected on the evidence of the record, where the Iridonian authorities are currently still investigating the appellant, and therefore there's no defense. Members of the panel, a failure to cooperate is absolute and strict. In the 2013 cast decision of Besiktas Gymnastic versus UEFA at paragraph 174, the court stated that corruption by its nature, as the parties will seek to use evasive means to ensure that they leave no trail to their wrongdoings. And in cases of match fixing, the panel considers that this position is also applicable and people involved will avoid using words in this regard in case they might be heard or wiretapped. The panel has no doubt that they will concur in private with as few people as possible. In the present case, the refusal to cooperate and to provide the mobile phone strongly gives the cast panel reasons to infer that the appellant is attempting to conceal his phone records and other relevant documents inside the phone, which may incriminate him and his accomplices as well as his father in match fixing. If I may direct the panel's attention to Exhibit 6, Exhibit 2, and Exhibit 3. Here the appellant acknowledges that he is aware that his father had been experimenting with cryptocurrency. And Exhibit 3 and 4 clearly shows that he was on the phone with his father the night before the game, and his father had asked him to follow him, to which he replied he could not do everything that his father asked him to do. So 2 points, members of the panel. He was on the phone before the night of the match, and he was asked to do something for his father. Along with the other evidence of the record showing that his father received 50,000 in Dogecoins, the inference is that the appellant was engaged in match fixing, and this violates a slew of articles under the FDC Code of Ethics, particularly on this issue, the duty to cooperate when he failed to provide his phone on 2 accounts, Article 12, subsection 3 of the FDC. In the 2020 cast decision of Alexandrina Nadenova versus PTIOs at paragraph 250, the panel held that the appellant pretended to cooperate but did not do so when she handed over a phone, but prior to doing so she deleted all the evidence on the phone, and held that this was a breach of the duty of cooperation. And in our case, accordingly, we submit that the 5-year sanction imposed by the FIFA committee for match fixing and the duty and the failure to cooperate is not disproportionate or evidently gross. And therefore, we pray that FIFA's appeal decision be upheld. Mr. President and members of the panel, if there are no further questions, this concludes my submissions. Thank you.